It's that time of the year once again, and it's that time of the day, it's that time of the week where we do what we do best, sharing pertinent information about the work of a very, very important department, Department of Justice and Constitutional Development. I'm saying very important because so many people out there from time to time will suggest or insinuate that justice is for people with money. True and true. In the past so many series, we've been trying to put the record straight. That indeed, justice in South Africa is for all, more especially for the poor.
Yes.
Now tonight, we're having a regular guest in our programs. A regular because she's been here so many times. She's Miss, I call her Khauji, Miss Khaukelo Likubu, from the Promotion of the Rights of Vulnerable Groups Office in the Department of Justice. It's a very, very serious office. Very soon she's going to tell us what is it that she does in that office. Welcome, Me, in the program, in your program, in fact.
Thank you so much for having me, and thank you for our regular listeners and our new listeners. It is a pleasure to be here to talk about sexual offences courts. We talk about sexual offences courts quite often because we have realized as the Department of Justice that sexual offences are committed against women, children, and other vulnerable groups.
Well. We understand that you do not want to come closer to the microphone. We are going to arrange this. Don't worry, you are going to hear her. She's got an hour to do that. We are going to adjust this microphone. You are going to hear her so well. You see, before we begin with our program tonight, in the light of what has been happening, we've got something that we are going to share with you, but not now. Right now, we just want, for the benefit of the listeners, to have an idea what is going to happen in terms of the objectives of the program. What is it that we want to achieve after this hour? We have very few of those objectives. We are going to share with the listeners so that they can evaluate us on the basis of those programs or of those points. If this program was successful, this program then will be successful if, one, we have managed to raise the awareness about the progress made in as far as these courts are concerned. If we have managed to tell the people about the progress, we can say, one, we've met one of our objectives. The second one, if the listeners can get to understand the significance of these courts, what is so important about these courts? If our listeners can get to understand that, we will say we achieved objective number 2. The third objective, it is said the new models of these courts, what is their role? What is their role? If people get to understand that these courts and these new models are not just like your special courts that will sit in December, for instance, to take care of the people who will go over the limit after consuming alcohol. People need to know the difference between these courts. And the last one, if we're able to educate the listeners about the types of these sexual offenses, because people get to be confused, then we will say we have achieved our objectives. What do you think,
No, I totally agree that we should actually we should actually ensure that the listeners know what are sexual offenses, what do you expect to see different in sexual offenses courts, and the model that we talk about, what is it and what is its value? How does it help complainants in sexual offenses cases to go through the system better than in other courts that are not sexual offenses courts but are mainstream regional courts dealing with sexual offenses? And also, we need to enable listeners to understand, if this model is available, what is your role as a listener in the community in ensuring that these sexual offenses courts are a success? They need to be a success because there's no criminal justice system that works without witnesses, that works without the complainant being in the court as and when the complainant is required. So, yeah, that's basically what we should achieve at the end of the day, and I think we can do that.
Thank you very much, Mrs. Elikobo. This is what we are going to do. We are going to share one microphone because it looks like this microphone is giving you problems. And what I like about this is the closest. We are very close now.
Yeah.
I'm sure this microphone now that we're sharing is going to be fine.
Okay, it will be fine.
How do you feel about the closeness, the proximity?
No, I'm comfortable.
Very comfortable. Thank you. Thank you. Now, the Department of Justice and Constitutional Development. Now I'm talking to the listeners out there, listeners of these community radio stations, has invested a great deal of money.
Yes.
We're talking millions.
Yes.
Some people, I'm not going to mention their names, they do other things with their money.
Yes.
But this department has decided to say, okay, we're going to embark on an educational drive to make sure that South Africans get to understand, like almost heightening the understanding of the people of South Africa about the programs of this department.
Yes.
Now, as part of that, it means there's a great deal of dent. You see, the feedback we're getting from the stations suggests that really it is working. Your strategy is working. People understand now. A point in case, some so-called bishop was sentenced yesterday. And people were very happy. This so-called bishop that goes around victimizing the people who represent vulnerable people, was sentenced. And we had an opportunity to talk with our acting DG here at GCIS. Listen what she had to say about the sentencing in particular of this so-called bishop.
Would like to re-emphasize that we will not tolerate rape or any form of abuse against women. This sentence sends a strong message that no one in society, no matter how high they are, will not be spared by the justice system. We wish to use the opportunity to also call on society to continue to work with government in making sure that the perpetrators of violence against women and children are brought to book. We also want to remind society that there is a toll-free number. You can do something if you know that there is somebody who is abusing a child or a woman. There is a crime stop number, 08600 10111, or the child line, 0800 055 555. And also, for those women who are in distress, would like to ask them to use the number 0800 428 428. It's a number that is available for 24 hours, and you can use it. As government, we would like to re-emphasize
that was our acting DG, Pumla Williams. In the morning, we meet every morning here to scan the environment and to suggest what needs to be highlighted. One of the things that we picked up was this, and we decided to say this. Now, your thoughts around what our DG has said and the sentencing of this so-called, because I refuse to call people like that bishops. You cannot, because the deed cancels the title. We can never, ever say as someone like that is a bishop. Your thoughts around that?
Well, I'm quite happy that there's synergy between the Department of Justice and the Department of Communications, because you are really at the forefront of the media and highlighting what is happening on a daily basis in the courts. It is very important that we bring back confidence of the public into the criminal justice system. It is precisely for this reason that we are having this talk show. And I would say that the law, it does not matter. You know, sexual violence happens against children, happens against members of churches. So there's no one in the country or even in the world who is immune to being a victim of sexual violence. So I'd like to dispel the myth that religious leaders are perfect people. We have to have a spotlight within religion. No part of society must be left to privacy, or we should not say that the church is untouchable. Even leadership of the church can be touched by the law. And what the acting DG was basically saying is that it does not matter who you are. The hand of the law is long enough and strong enough to deal with you, irrespective of your position. And this we must, as South African, accept as something that is a positive move.
Well, at this point, we are going to have to tell our listeners we're doing something different.
Yes.
Ordinarily, the program and everything about it will be taking place here in Pretoria. Yes. But today, the producers of this organization decided that they're going to be all over the place. Karabo was somewhere in Niger, working with the president in the launch of the presidential rail project. I see him coming now with a big hat and is even sweating. Another producer, Msutu, is stuck in some airport in Cape Town, was supposed to be here. Can you believe this? And Nonhlanhla, our Rose, is stuck somewhere in Free State on a DTT program. You see, it's tough. It's tough. But we said as GCIS and Department of Justice, the program is going to go on.
Yes.
Now, we had to fuse these studios. We are connecting this studio with the studio in Cape Town. And as such, the callers are going to have to use this number if they want to engage. The number that they're going to be using, because I know they're going to be tempted. They're going to be tempted to call the old number. Now, the number they're going to be using is 0800 314 446. I know the number is confusing because it has almost similar digits. Let me say that number again, because I know they had to go and get the pen. The number is 0800 314 446. That's the number to call if you want to engage on this program. Remember, this is justice. Justice is moving with time. We're on Twitter at DOJ&CD_ZA. You can interact with us in that fashion. On Facebook, the Department of Justice and Constitutional Development. You see, as early as tomorrow, you can get this program on YouTube.
Yes.
We have one handsome fellow here who's tilting and panning the camera so that you can see this thing on your YouTube government website. Just go to government website and say, let's talk justice. You will see all the images of this. But now, Me Likubo, your office suggests best part of your work is to deal with cases of this nature. Let's start from your office. What is it that you do?
My office is basically a division, a directorate called Victim Support and Specialized Services. This is a division that falls under the Chief Directorate Promotion of the Rights of Vulnerable Groups. So we take all laws that are actually affecting vulnerable persons and deal with those laws and make sure that we have special programs that are aimed at addressing the needs of victims of crime that are relating to vulnerability. And as a result, we are responsible for looking at sexual offenses against children and adults through the implementation of criminal law, sexual offenses and related matters. And we have been, to this effect, able to bring further legislation. The second, it's the Criminal Law Second Amendment Act, number 43 of 2013. It basically puts in place a legislative provision that empowers the Minister of Justice to establish and designate sexual offences courts. So the development of sexual offences courts, or the establishment of sexual offences courts, is a program of government that is legislated. That is one thing that we would like the public to be aware of. Currently, we have 74 sexual offences courts. These courts are established and working. They are not yet designated by the minister. I need people to be aware of that. And the reason why you should understand the difference is that the commitment of the department is to the effect that we have gone ahead of the law by saying that we're establishing this whilst the department is developing a regulation framework for the minister to be able to designate. So what it means is that there will be sexual offences courts across the country, but as we develop them, the minister will designate some of them. And when he designates them, those sexual offences courts would have to be hearing matters relating to sexual offences exclusively. Yeah. But the department is saying we want the very same model to be available and accessible to other people. So there will be some other sexual offences courts that are designated but not necessarily unavailable to the public. So I would like to say the model basically is saying we are cognizant of the fact that when victims come to court, sometimes they are in a state of trauma that they cannot face the accused directly. And in terms of the Criminal Procedure Act, there are particular provisions that enable the prosecutors to say that whereas the principle of law is that any case that is heard in court must be seen to be done. What does that mean? It means that the public should be able to listen and see justice being done. So you could go into the gallery. But the nature of sexual offences, honestly speaking, is a matter that goes to the dignity of the person, number one. It's very personal. It talks about things that are deeply private, because sex happens in a private sphere, and it's about your personal protection. So you cannot talk about your private parts easy, or when a person violates you, you need to be protected by the system. So the model, what does it do? If you feel like you cannot talk in public, you can apply through the Criminal Procedure Act, through the prosecutors, to say, look, I want to have my case being heard in privacy. And when we say that, how do we facilitate that? People should still be able to hear the law being done. We make available through the sexual offences testifying rooms. Testifying rooms enable the victim to give evidence from a comfort of a room separate from the court. It doesn't have to be, the victim doesn't have to be in the same space with the accused, through CCTV systems. And that is basically making the law real for people by bringing these facilities like testifying rooms and using CCTV cameras. There are other aspects over and above institutional frameworks.
Before we go there,
yes,
I promise you, I'm never going to ask you an open-ended question again, because it's like I can see the passion going on and on.
No, I'm answering the questions that you said we must answer.
It looks like you're answering all my questions before I even ask them. Oh, okay. No. I like this. Right. I like this. This demonstrates the passion that we have in as far as this work is concerned. The reason I had to do that, I just needed to apologize to the listeners. For a second there, we were off air. Something happened, but right now the producers have fixed it. Everybody can hear us. And right now I'm told Undate Mkhweng Matala, Undate Mkhweng. Undate Mkhweng. Okay. Now Murena uri.
Ritem papa ka le kaino.
Umunate man. Ritutsi limme.
Man. Papa.
Andate.
Molao o reng? Udimo batho ba ile ba itshaupa ba sign or ba berekela morao. Ntse twa tswa re ntshwa dirang mo mothong la mo emelelang is wrong completely, is not going to win it just because of the money. Why kenela yena in a lawyer? What is the law saying about that? Because especially mo Limpopo mo na le corruption just because of money. Mina tlemanga they are culpated because of that. What action has it been taken or should be taken against the lawyer? What malatola ke malati but just because of the money yena wa o kenela a defendela mothola.
Ndate Mkhweng, your surname is so powerful. In fact, when I grow old, I want to be Mkhweng, Linna. Linna, I want to be Mkhweng. Perhaps I could be the judge or chief justice. Now, Likubu is going to respond to your question right now. Akirime.
No, ka boripana Ntate Mkhweng, ke tla re molao ka mkholeng ka teng justice e alawa gore re be le prosecutor, re be le a lawyer. An accused in terms of the constitution ona le tetlello o ditokello tsa go ba le mueledi o tla mo emellang le ge e le gore re nagana gore molao o robile o tshwanetse ra prove beyond reasonable doubt that the person or being accused for committing that particular offense did commit it beyond reasonable doubt. And this is a principle of law that we cannot run away from. It is a basic right that is enshrined in the Constitution. Now, what we're trying to do with the sexual offences courts is to tilt the balance, to make sure that molao how protected the accused fela, but little complainants or the victims the sexual offences bana le sufficient protection from the law. And we do this by providing the buildings are friendly for the victim, to make sure that we protect them. Court. Number 2, it's a human resources that we provide in sexual offences. It's not prosecutor engwe le ngwe e tshwanetseng ya nna ko sexual offences court. Re batla a prosecutor e leng gore e na le maitemogelo ka go ba a prosecutor, number 1. Number 2, e na le maitemogelo ka go dira ka gender-based violence legislation. So, and thirdly, slowly but surely, we are introducing the services tse di tlatlang ka deep court personnel, like book court preparations. You see, in a sexual offences court, re ensure gore go na le court preparation ya the victim o tlatlang ko court. A tsebe gore ha a tla ko court ke bo mang ba leng gore ba tla be ba le mo go tla ba o tla ba boleliwa gore go na le moeledi, and tiro ya gagwe ke gona gore a leke go bontsha gore offense did not happen, or a se motho o a leng accused a committing. Ha ba ile gore o dirile an allegation, you will be able to stand in court and say, yes, this is the person who committed an offense against me on this day, and enabler through court preparation re o understand gore role ya motho o mong le o mong a leng mo court ke eng, so that ha o tshose ke role ya moeledi o tseba fela gore ke o dira se leng gore o se hiretswe ke the accused to do. And then wena le prosecutor le court preparation officer, you must be able to prove that no, the offense happened against you. And yeah, so one of the services ke court preparation re fa hona le tse dintse ke tla buang ka tsona after.
Thank you, me. In fact, before I take this caller, Sfundo, on the line right now, it's a Christmas today. We've decided to open both the calls, or both the lines, the line in Cape Town and the line here in Pretoria. No, you can use both of the lines. You can call 0800 142 446, the one that you've been using for this program, or you can call the other number. You have another producer sitting in Cape Town, Fundo Magaba. The number there is 0800 It's 0800 314 446. Yes, I got it right. 0800 314 446. At this point, let's go to Untates Fundo.
Yes, sir.
Yes, sir. You are
Good evening.
a very good evening, sir. You're on air.
Yes, my name is Fundo from Ladies and listening to
Ngubeko.
This question, yes. With regard to this Cheryl Zondo case and Omosoto case, and the questions being asked to the victim, how relevant are they, and what's the sensitivity around this type of questions, even to minors that are being raped? Is this the kind of enforcement that they face when in the witness box to be questioned and all that?
Yes, you know, as the official of the Department of Justice, let me just say that this case is what we call it sub judice. So I cannot comment on the case currently. But I can comment generally on, I would say, yes, when you are in court, because of the nature of justice, the nature of us wanting to go to the truth. We don't want people who are not guilty to be found guilty. You find that the system is that adversarial. That's what the courts, such as sexual offences courts, try to mitigate against. We try to make sure that before the victim comes, or the complainant, in this case, the complainant comes to court, they are prepared, they are told that you will find a person called a lawyer, and they are within their rights to ask questions, and a prosecutor is there as the victim's advocate. He knows what should be asked and what should not be asked. So we need to trust the system to say that the prosecutor is there to stand for you and is there to protect your rights through application of the law. So court preparation will explain the role of the prosecutor, the role of the attorney, the role of the presiding officer, the role of anybody else who might be within the court at any given point. But sexual offenses, by its nature, is very traumatic, Puti. Whether it's an adult or a child, it creates a burden on a person who has to relive their experience. So it's not an easy thing, hence we bring sexual offenses courts. Currently, we are having a debate as a result of the total shutdown move of the 1st of August, where they demanded, as one of their demands, they demanded that we have a summit around gender-based violence. Women and children and other vulnerable groups experience different forms of gender-based violence. And it is for us to start looking at, we're going to discuss what are the other kinds of services that we should bring to forward in order to protect our victims, so that our victims can be able to go to court and present. They can be emotional. We need to be able to say, in these situations, the victim should be able to have somebody like a court support person or a supporter, court supporter. A court supporter is a person that will come and sit next to the victim, and when the victim feels emotional, they can at least give them a glass of water or help them to recompose themselves, because when you relive a bad experience, often it brings tears to you, it breaks you down. But if there's somebody that you trust, whether be it your mother or be a member of an NGO there holding your hand, you know that, or at least I've got somebody who's urging me to be strong. It's not guiding me to say things that did not happen. It's just there to help me go through the motions of giving evidence without breaking. So often that maybe you end up being in court for a longer period of time. So unfortunately, Sfundo, I cannot talk about this particular case, but I will talk about general principles of law and what is expected and what can be given. So victim support services are given. And also, I mean, one of the things that we are now talking around the summit is to say, when we have sexual offenses courts, what are the additional services that we want to give to the victim? We need to be able to say the victim can have time to go and what we call it to compose yourself, and emotional containment. We should allow for victims to know that there's somebody who's waiting outside. If you feel like you're not going to talk, or you feel like, normally we say that there's a lump in your throat, that's when you know that I'm going to cry now or I'm going to break. We need to be able to educate victims that, can I be given a moment to go out, to take some breathing exercises so that I can continue with. At the moment, I don't think I can continue giving, so that their dignity is protected, because no one wants to cry in front of people and be seen as if they are weak, you know. So we will be using the opportunity of the summit with the various organizations within the community, civil society organizations, to really say that we've done what we can. Maybe we haven't done enough as government. What are your ideas on how we can protect victims of gender-based violence, including sexual offenses, better?
All the way to Western Cape, we have Ntate Grant from Worcester. Ntate Grant, you are on air.
Good evening, Chief. Good evening to the guests.
Evening.
I'm listening on Worcester FM 89.2. And I want to agree with Edith Lennox, the presenter, when you made an opening statement and your remarks about, the bishop that was sentenced yesterday. And I want to agree with you. You can't call a character like that bishop because the acts are not in line with the title. We have a situation now in PE with that pastor. You can't call him Pastor Umoso.
That's how I feel, and I feel strongly about that.
And I concur with you.
Yes, sir.
Because if you're preaching the Bible, you should know the Bible describes the characteristics one must have if you are in that particular office of a bishop, apostle, whatever. And we have a situation now, we're seeing it all over the news, and we're reporting it we're hearing it on the radio station here in Worcester FM in the day about how the victim in that case in PE is being treated. That advocate Doberman, already with that name Doberman. Like
exactly.
The way he's handling it. I want to know how is the system and the department protecting the victim. Look at that young lady. She's a university student and how she's being portrayed. I mean, that stupid question that man asked her about how many inches.
We don't even want to go there. We don't even want to go there, really. But, yeah, very emotional and very emotive case that. And that Grant, was that the only question?
Yes, I was. Thank you very much.
Thank you very much. Keep up the good work with Worcester. All the way to, I'm telling you, Western Cape is dominating today. Grabo, and we have you on the line. Hlumisa, you're on essay.
Hello.
Hello?
Hi, yes. My name is Hlumisa. I'm calling from Grabo.
Oh, Hlumisa, you are on air, my sister. Thank you very much for the call.
All right. Firstly, I would like to, I would like to comment, just a compliment about what you guys doing, the programs that the DOJ brought for for us as listeners of the community radio stations. We're really learning a lot. I would like to comment about that.
Powerful feedback that.
We're really learning a lot.
Thank you.
The question that I've got, I'd like to find out, she spoke about the toll-free number. I think it's 08 00055, something like that, but I wrote it down for the child for the victims. But I'd like to find out from her, how soon do you guys respond? Because remember, we are from Grabo. It's a small place. Even sometimes when you need help, you are in trouble, then it's difficult to get help. Some of us were in the farms, so it's really difficult. So how soon do you respond from those toll-free numbers to assist, the victims? This is my question that I have. That's the only question.
Thank you very much, Siswam. You're representing the area very well. Thank you very much. Right. Now, all the way from Grabo to George. George is in Attersville. George, you're on essay.
All right, thank you. And then Mama Haugelo, Likubu. Can you question at Matomoko, Victoria, Department of Justice, Baneligi, DVD, information, sexual offenses, the victims to be familiar with just to prepare them or maybe to empower them before Bako Yako the court. And then you have two questions with Sagadi. Sexual offences court or regarding or by the sexual offences court, and then if it is paying the server purpose they fulfill, and then also the fulfill their intended purpose. I did questions about that too.
Thank you very much. Very representing there all the people of Attersville, George, from Peli FM. Very difficult questions. But I know you have black belt.
Yeah, no. I comment by Graham. I cannot say it's wrong. Actually, by prefixing their names with bishop and pastors, I guess people are using the principle, you are innocent until you're proven guilty. So, unfortunately or fortunately, our constitution is a constitution that says let the person go through the entire criminal justice process. And then once they are convicted, we can take the title away from them. So let us be very, very sensitive to the fact that we live in a constitutional country that says that an accused is an accused until we can prove that they committed the offense, and after that, then they become a convict. Then they can go to jail, or they will serve community sentences. And in sexual offenses, we are trying to say, as far as possible, the violent nature of sexual offenses requires, of some of the sexual offenses requires us to send people in jail. But in some of them, unfortunately, we've seen judgments where people are treated leniently because maybe the violence, the sexual offense is considered not so violent. And that is the problem that we're having. We want our public to understand that all types of sexual offenses cannot be tolerated. We've got zero tolerance to any form of sexual offenses, whether be it sexual assault. Sexual assault is when you might even utter words to the effect that you will harm a person using sexual language. In that case, we should say nobody is allowed to use language to make somebody fear that a sexual offense is going to be committed. People who connive with others for others to be sexually assaulted or for sexual offenses to be committed, we call them, there is a collusion where you collude. You are just as guilty as the person who commits the sexual offense. There are other offenses where a person does not really participate in the sexual offense, but they threaten another person. As they could go to you and say, you commit a sexual offense against B. If you don't, we're going to kill you. That person is using an instrument, you as an instrument of committing the crime. We will find you guilty as a perpetrator of sexual offense. So, in effect, what we are saying, all forms of sexual offenses are taken seriously by our courts and must be taken seriously by our courts. If the victims are not happy, they must raise their voices to say, we are not happy with the sentence we would like, because the prosecutor is our advocate. We would like you as a prosecutor to appeal this sentence. It's lenient in our point of view, and we call upon CSOs to play their monitoring role. If you are not happy, cases at magistrates' courts can be taken on review. Cases can be taken on appeal so that we overturn. We've seen quite a lot of cases where a sexual offense is committed, and if there was a lenient sentence, by taking on appeal, a more harsher sentence is applied. So it's the principle of justice. Trust the system to ensure that we don't unfairly or illegally find people who are not guilty. We must find those who are guilty. And unfortunately, the system allows, it's an adversarial system. It allows for cross-examination. It's the nature of the justice system. But we should not leave victims to be harmed by giving evidence. Hence, we bring sexual offences courts, and we make sure that we increase services for victim support, to support the victim as they come into court, when they are in court, and when they leave. We are not strong enough, but we believe that with conversations with civil society organizations, we can share ideas to see how best we strengthen the victim support services for victims of gender-based violence, including sexual offenses. We had also another question that said, I've touched a little bit about around sexual offenses, the different types of sexual offenses. There's one that we say is horrific, it's rape. But there are, when you are a child, you are a 14-year-old child. A 14-year-old child cannot consent to having sex and enjoying sex with an adult person. Let's get it clear. Let's not get it twisted. It's an offense that we will go against you as an adult who has violated a child. That one is clear. We will say there is no mercy. You can say, no, but there was consent. You must prove that the child pretended to be an adult. If you cannot prove that the child pretended to be an adult, we will prove as prosecution, as prosecutors and people who support the victim, that this person is a child, you knew is a child who comes to your school, but you continued to groom them. You continue to groom them in order for them to accept your sexual advances towards them. So the law is very clear. Grooming is an element that is used to make children to acquiesce. Acquiescing is consent, but we will prove grooming. And once we have proved that you have groomed that particular child and that child did not present themselves as an adult to you, and you ought to have known as an adult that this person is a child, you are not supposed to have a sexual relation with that child, will go against you as the law. So that's another type of sexual offense that we must be very clear. Another thing, we've got services for children. If you are a child and you feel like you will be stressed, you'll have undue mental stress by giving evidence, the prosecutor must apply to court to say that that evidence must be given in closed court. And the testifying rooms are used for that. And we have designed the CCTV system, the closed-circuit television system, such that the child does not have to see the accused. They can be asked questions in the comfort and security of a testifying room. They can be asked questions by the attorney for the accused. They will answer through an intermediary. Now, an intermediary is a person who, if the child cannot talk because or doesn't understand court language, the intermediary will be able to explain the questions from court in child language and relay the child's answer back in court language. So intermediary services is another form of victim support service that we provide.
Okay. I don't want us to lose Thabo from Zibadile. And I don't know if, again, you've responded to Hlumisa's question regarding the toll-free number and to George's question regarding the access to some of these things, brochures and what. But before we lose Thabo, let's go to Thabo all the way to Limpopo. Thabo, you're on air. Umunati ujwa ntate.
Aga lena ke ne ka tlhela ka la utsiwa nang ke bitsitse diangwa
ra utlwa.
ora be ke re ka gore sexual offense court di tlhomile ene go na le melato e mengwe le gore ga sanka ya bega ya ditlhoriso tse di diragalang tsa sexual offense di diragalang mo malapeng a le gore ga jalo kora le bana ba ditsuana motlhomongwe di a ke malemo a tlang ga ntsi a ba fa maseleng go di ga kgwedi ngwane wa ana tsebo ya gore ke tshwarisa ka ba e bega ke ditsa gore bona ba kgona go ba le ba le reng ke ba golofadi re ya tsare ka fale le ba go feta re ke kgwedi ya bona ya felelela ke fale e namile bona di gore di case tse di kgone go fitlhela court ge batho ba sa kgone go tsala go ka melato ya mofuta ke tsela tse di le gore ba di dira ke le gore ba ka kgona go tsebara wa dikhoto tse di gona ene batho ba tsela bega melato e kgone go pasa.
Okay. ra kwagala o botsisitse question e ya tshwana le ya question and e botsisa gore di kae di courts
yes di ka George
a rena di courts rena le 74 courts sexual offences courts across the country. Now they are not available in each and every magisterial district, but as far as possible, if your district is nearer to a sexual offences court, it depends on how the district manages that particular the sexual offences. Often you would find that the complainant, if it's a child and they have to give evidence from the privacy of a testifying room, they'll take that case to the nearest sexual offences court. And for the child and the guardian or the mother or the parent to go to court, we provide another victim support service. We call it a witness fee. So whenever you travel to court, when you leave the court, you are able to fill in forms to say, I've spent so much money to come to court, and therefore I need to be compensated. And there's also a little bit of money that can be provided for your expenses, like food expenses. You go there, you have lunch. Obviously, you're not having lunch in the comfort of your home. You've got to spend money. We compensate at a minimum of 50 rands where, there's not real evidence. But if you go and if you can prove that you spent more than 50 rands, then you must prove to the court manager that you spent more than 50 rand, and it will be compensated. Sometimes in very critical cases where the security of the child is at stake, the police investigate the FCS investigating officer will transport the child and the mother to the court, but that is not a standard procedure. It depends on the security. We look at the threshold of the security of the witnesses. It's not a normal procedure that is done by police, but they go the extra mile and they have assisted some of the victims who require that kind of protection. But as I said, we are increasingly spreading out the sexual offences courts, ensuring that they are available. Remember, the model is you did say that it's a finance intensive model. The kind of resources that we bring, we require 2 prosecutors, we require intermediary, we require court preparation officer to be at that court. So as a result, we will establish these courts primarily in, number one, in areas where there are high rates of sexual offences. You understand? We can't make them available in areas where you find that there's like 9 cases in 3 months, because we have to use resources very well. But those cases can still be transported to the nearest sexual offences court. And then the second issue that I wanted to address is that if the family cannot go to the police, at least you must, within 72 hours where there was rape, go to your nearest clinic or your nearest hospital so that they can take evidence from the child, and that evidence can be preserved. Do you understand? It will be preserved, and maybe when you feel comfortable to go to report to the police, you can go. But at least one thing that you would have done, you would have gone to your local clinic where evidence would be protected. When you get to the clinic, to the hospital, ideally what they will do is they will call a police official who will come with the evidence kit and give it to the nurse so that that information, that evidence is protected. It's highly critical that evidence be presented within 72 hours, because the victim will not have washed. Make sure that you don't wash the victim if it was penetrative sexual offense.
Okay. Now, I know it's good when there's a dialogue with the listeners because, like we've said, very emotive. Now, let's go to Val, all the way to Ntate Mpaga. Mpaga, we are on air.
Le ka me pa
O loka malku jwa ntate.
ho lokile ntate wa ka ke ne ke dumedisang ne gaugelo mo le wena ntate wa ka ne ke na le potofela ya medical evidence like ha re sebedisa fela case ya Zondi hore it has been the first sexual offense. It happened 14 years ago. But while she was 14 years, but now she did not report the case. Now, how the court is going to determine the medical evidence that really indeed the sexual offences happened in that matter?
Okay. Let me just warn the listeners. We have 3 minutes to go. I don't know if my producers that side, or I can see there's the last caller. Oh, that was the last caller. Okay, that's good. Because I know Likubuye has so much to say. I want to give her as much time as possible to teach the responses.
Okay, there was a question by Promisa about the toll-free number. The toll-free number is available 24 hours. It's a number that is managed by the Department of Social Development. I don't know the nitty-gritties of response time, but ideally you should be able to reach the toll-free number, and you should be responded to within a very short period of time, because there are sufficient, or there are counselors who are on duty, and we put sufficient counselors to be able to respond to the toll-free. So it does not matter where you are. Even if you are in Grabo, technology works such that first come, first serve. And ideally, you should be able to get assistance immediately. George from Attridgeville, we do have information that assists victims. We do have a DVD currently that assists victims of sexual offences by explaining what court preparation is, and basically goes through explaining the roles of different role players who come to court. And then we also are trying to make sure that the materials that we develop are responsive to the questions of the witnesses. The one that we have developed recently is to enable the witness to deal with the trauma of giving evidence in court. Now, I believe that being in court is not a simple thing. Even in non-sexual offences cases, it's a very scary event to take place. So we've got a pamphlet that we use to give the complainants and witnesses ideas on how to deal with stress. Number one, we enable them to identify stress. And then number two, we give them tips on how to address those stressful stress symptoms. And then about the medical evidence, it is a principle of law that normally you adduce evidence to prove that an offense happened. It's not always that it should be medical evidence. We have what we call circumstantial evidence. It's through the circumstances and your reliability in your case that will help the magistrate or the judiciary judicial officer to determine whether indeed the offense happened. It's your viva voce evidence, your vocal evidence, as well as other circumstantial evidence that will enable the judicial officer to come to a conclusion as to whether the offense happened or not. Thank you.
Oh.
And listeners and my colleague, I just wanted to say my name is Kamogelo Likubu Walderson, not Kaugelo. But mistakes are made, and my friend, I'm Kamogelo, not Kaugelo.
Oh, not Kauji. Okay. Okay. Kamogelo. Okay. Now, just for few seconds, your parting note, because you see, the CEO of Soul City, Lebu Ramofoka, is presenting a challenge to South Africans. She's saying all these other professions are changing with time. There was a point in time teachers could not corporal punish the kids. In fact, they used to do that. Now they are no longer doing. That has been outlawed. You have the doctors who could not perform abortion in the clinics or in the hospital. Now they do that. Now, the point is why this profession seemingly is moving slow, where they are going to equate or balance the rights of the perpetrator and the rights of the victim. We can, just for a few seconds, where the possibility exists that tomorrow things will be the same or things will not be the same as we part ways.
Unfortunately, I'm a lawyer who comes from a jurisprudential background of common law, and that jurisprudence says that in order for a person to be charged and found guilty of an offense, we need the state that brings the case on behalf of the victim to prove beyond reasonable doubt. And there's certain evidences that have to be put in place to do that. But you are asking very critical questions that we will be asking at the summit. Today, actually, the law and policy task team was asking a question that can't we change from an adversarial system to an inquisitorial system for children and people with certain types of cognitive disabilities or cognitive impairments? Because we can't say this person's need is the same as the needs of an adult person who has all the faculties and all the ability to give evidence on their own behalf. So those questions are being asked. They are critical. The other people are saying, why don't we turn the tables and make the accused prove beyond reasonable doubt that he did not do the deed. You know,
I like that.
This is why we're having the summit. Let's have conversations. Let's have ideas and check whether these ideas that we will be putting forward, are they able to stand the constitutional test? Remember, we are a constitutional state. We've got the most beautiful constitution in the world. That is the constitution that will decide whether we can turn the jurisprudence of gender-based violence. Thank you very much, listeners. I appreciate the questions that were asked. Bye-bye for now.
On that note, we have come to the end of this special broadcast brought to you by the Department of Justice and the Constitutional Development in collaboration with Isaiah's